as a strategy for compliance with international environmental law, especially in Japan and Australia. So, and we focus on biodiversity. So, we know that our climate litigation has evolved a lot. But unlike climate litigation, biodiversity litigation is an emerging category. So, these days, so far, many new literature has evolving, but still not so many. So, and the cases in Japan are not well known over the world. sorry. So this is our research focus and methodology. Sorry, again. よいしょ。So core question is how do domestic courts in Japan and Australia apply international biodiversity law? So these two countries have legally different legal systems. So Australia has a federal system. Japan has not federal system, but we found some commonality and difference. So, and we selected treaties as follows. So we examined the cases which applied the following the treaty, like a convention with about biological diversity, CBD, and World Heritage Convention of WHC, and Ramsar Convention on Wetlands, and a Convention of the International Trade in Endangered Species of Fauna and Flora Sites, and Japan-Australia Migratory Bird Agreement, JAMBA. And case selected criteria is examining recent diversity case law between 2010 and so far this year in Japan and Australia, focusing on the application of international biodiversity law in domestic settings. The dispute primarily relates to the conservation of species and our ecosystem, and also submissions argued directly or indirectly on breach of national obligation under the selected international biodiversity treaties. So methodology is comparative approach, comparing legal arguments and findings from different judicial systems. So let me begin with the Japanese cases. So we have a very rich diversity. Japan has approximately 38 million hectares with over 19,000 estimated species, so diverse. Especially Kyoto has a lot of rich biodiversity. So potential up to 300,000 with unclassified species. And also, as we are an island country, we have a high endemism. Nearly 40% of land mammals, sorry, my kids are coming back, so sorry, a little bit noisy, but mammals and vascular plants, and 60% of reptile, and 80% of amphibious and endemic. But however, degradation of ecosystem and rapid loss of biodiversity are urgent problems with persistent decline in 6 key ecosystems: forest, agriculture, urban, freshwater, and marine and coastal islands. So biodiversity loss in depopulated areas are also a concern. So Japan has facing a significant population decrease. So many people are moved in the urban area. So many rural areas facing this problem. And also citizen engagement litigation is one field of that citizen engagement. But still, a litigation has been used by citizens to protect this rich biodiversity with some plaintiffs, very limited plaintiffs seeking application of IBTs. So, regarding the legal system, adoption of international treaty in Japan, let me introduce a lot of some core point of legal system. So initially we adopted the monistic system. So Japan adopts this system, meaning that treaty ratified and duly published immediately recognized that they have in domestic legal effect without further legislation. And also, constitutional obligation is specified in some article. The Japan Constitution established obligation to comply with this treaty in good faith. And also, prevailing view is that the Constitution is supreme over the treaties. But treaties are generally considered superior to domestic laws based on some article in Japan. So treaty provision can be directly applied if they are clear and precise. This is what the Japanese court has been said. So this requirement rooted in the separation powers hinders active direct application as the IBT contents is often not clearly defined. So we have a data selection many cases, and one case from Shizuoka Airport case found CBD Article 8 and 9 did not directly constitute specific legal norms. And the next, we have other tools to the so-called indirect application. Japanese courts, including the Supreme Court, are increasingly open to interpreting domestic law by deferring to international law, not directly applied. So some example is Nibudamidam case, which is occurred in 1999. So Sapporo District Court in Hokkaido referred to ICCPR Article 27 for Ainu people. Ainu people is indigenous people in the Hokkaido area. So they are cultural rights in the interpreted compulsory purchase of land acts. And also, National Act case was also the one case. Supreme Court invalidate the act of constitutional ground by deferring to ICCPR and CRC. CRC is the Convention for the Right of a Child. So the domestic role in practice, court often apply relevant domestic laws like the Basic Health of Biodiversity enacted in response to CBD ratification. So limiting direct treaty application so that court feel safe to apply in that specific case. So from here, I give the floor to the Ivan. Please continue.
Oh, thanks, Masako. So I'm going to talk a little bit about the Australian context in a similar way in which Masako did, because we followed the same methodological process through our two jurisdictions. So biodiversity in Australia, many of you may know or may be aware that we are a mega biodiverse country, and it's a very sensitive environment in many ways. It's a harsh environment, but very sensitive in other ways. And so a lot of the species are quite sensitive to changes as a result of urban development, mining, obviously climate change, and agricultural impacts. So what we've seen since the arrival of Europeans in Australia is a number of species that have gone extinct. And really a lot of our more sensitive ecosystems, especially marine areas, are really up against it. And so we have these, every few years, we have these state of environment reports where the scientists get together and provide official view to the government about the reasons for decline. And almost always these reasons for biodiversity decline are the same. They're inappropriate fire regimes, their climate change, their cumulative impacts due to urbanization, deforestation, and also invasive species. Next slide, please, Masako. Yes, that's right. Okay, so a little bit about how international law is adopted in Australia. So given that we're a federal system that must take account of the interests of the states in the application of our international law. Now, the right to sign treaties sits with the executive at the federal level, but there is this process that part of it is by convention, but part of it is also set out in a committee system that requires some level of consultation with the states and territories before a treaty is signed. So, for example, at a federal level, we have this Joint Standing Committee on Treaties, which will provide advice at the federal level as to whether the Parliament should ratify, and then we require the implementation in domestic law for that treaty to have effect. In the context of environmental law and international environmental treaties, the federal government really gets most of its power for environmental issues or to control impacts on environmental issues is probably a better way of putting it, through what is known as external affairs power. So this is a provision within our constitution which allows for the Australian Parliament to pass legislation provided it is appropriate and adapted to the purpose of to giving effect to treaty obligations. So as you'd be aware, Australia and many other countries, though not all, have signed these treaties: Convention on Biological Diversity, World Heritage Convention, CITES, Ramsar, and many other multilateral and bilateral agreements. So through the signing of these arrangements and the implementation of them into domestic law, this is the reliance upon the external affairs power that we see happening in Australia. It's not the only mechanism by which the federal government can get control, but it has been the main one to date. Next slide, please, Masako. So I should just note that our study is mainly focusing, or at least from the Australian side, on federal national environmental law. There is some indication of litigation at the state and territory level, in fact, there's a lot of litigation at the state and territory level that involves threat species, biodiversity, ecosystems, and so forth. But because of what I was explaining before, it's actually the federal government that has responsibility for the signing and ratification, implementation of treaties. So the states and territories are essentially non-state actors within that regime. However, there are cases that I'm aware of where those state and territory courts have sought to apply principles from these treaties. So that is not unheard of. But the direct application of, for example, the CBD, or lack thereof, as we'll soon talk about, happens at the federal level in Australia. So it happens principally through this piece of legislation called the EPBC Act. We have horrible acronyms in Australia, so I apologise for that. It's been around for about 25 years, so at the national level. And it is kind of a one-size-fits-all legislative approach to implementing Australia's international obligations under these treaties, which I talked about before. Where does it cut the line with the states? Because the states also have responsibility for land use as well. It does it on this terminology of significant impact. And the other language that might be helpful to be aware of is this MNES, Matters of National Environmental Significance. So this creates a little bit of duplication because, so for example, biodiversity at a state level will have state significance if there's, for example, koala populations in New South Wales. But those koala populations will also be protected at the national level because they've been declared as having some sort of national environmental significance. So we kind of get a very duplicative, overlapping approach going on here. So under this piece of legislation, most of the challenges, most of the litigation, not all, but most of it happens by way of judicial review. That is attempting to hold governments to account for the decisions that they make or don't make, and looking very carefully at the reasons for the decision after the minister made a decision, or their delegate. So 9 times out of 10, it's the delegate in their department, but effectively it's the minister's decision. So there is no merits review under this piece of legislation. And so most of the cases that we looked at over the last 15 years have been as a result of this judicial review process, which of course provides limited remedies, as many of you would know, is generally for the court to then say, after the litigant has spent some $50,000 or $100,000 trying to get a result, to send it back to the decision maker to make the decision in accordance with law. And it could so happen that you're back in the same situation as you were before and the biodiversity is not protected, or the ecosystem and whatnot. There are some what's called known as expanded standing provisions in the Act, which are hard fought and still exist in there, although several years ago was an attempt to remove them by the Conservative government, but they stay in there. And they are, if you can demonstrate, don't quote me on this, or I don't have the provision in front of me, but it's essentially if you have been involved in environmental protection, you or your NGO, for the last 2 years, and you can demonstrate that you have been involved, then you have essentially extended standing to become a person aggrieved in order to bring an action against the government. Otherwise, you fall back into the general category of a person aggrieved to challenge a decision under judicial review, And that's very hard to make out in the cases of public interest litigation. So we're fortunate in a way to have these extended standing provisions, but also it's not, there have been cases where the court has said, no, we don't think you actually have met that test. Next slide, please, Masako. I think this is over to you now for the next few slides.
Okay. So, ちょっと待って。
Oh, you've gone ahead by one slide.
Here,
That's
yeah.
right.
So, thank you for everyone for sharing your Australian situation. So for we just shortly described two situation of two countries. So we like to argue that the reason why are the number of cases so limited. So this is our first question. So this is our common challenge as well. So and we find some reason from the case review, and we find that difficulty in establishing standings. So especially in Japan and also areas. Japan is low rate of litigation generally. So Japan is very famous country as a low litigation use compared to other countries, and also high barrier to legal advice. So court requires concrete factual circumstances and concrete legal harm. But environmental rights are so not explicitly recognized, making it difficult for individuals to claim harm for biodiversity loss. So this is the climate litigation shares the same problem, but when it comes to the biodiversity, it is much more difficult when how we explain my rights of the environment is harmed by biodiversity loss. It's very difficult point. And also, you in Australia, tradition maybe Evan you explain or.
Sure. So as I was saying before about the standing, it is extended standing under legislation, but that has been controversial, as I said, and not in every instance is the litigant able to show that. But not only that, once they actually do get over that 2-year expertise barrier, there still has to be some level of special interest, which is more than just a mere intellectual or emotional concern over the environment. And so these are early hurdles for the litigants in Australia.
Yeah, so let us move on the second point. So why the number is clearly limited, and a second point is lack of access to resources. In Japan, limited number of legal professionals are concentrated in cities. So many attorneys live in cities because there are a lot of cases, and limited financial support. Financial support is very indispensable when the citizens continue their legal activities. But the culture of donation is very, very low in Japan, so which hinders many citizens to fight for the biodiversity, which is a little bit far from their individual rights. So, Ivan?
In Australia, one of the bigger factors, which continues to be the case, is the costs. So they are the need for the access to the expertise. So most of these actions require significant expertise. And the experts, who are the environmental scientists sitting in universities or in other institutions, are essentially providing their advice to the court, either a very substantially reduced fee or pro bono in many cases. So those increasingly with complex cases, that's hard to find. Then we also have these barriers, which is the normal litigation barriers about costs following the event. So if you lose, if the NGO loses, or the concerned community group loses, then they could be up for substantial amount of money in these fines. In the event of a loss.
Okay, so finally, we find few options for litigation process and remedies are provided by the law. So in Japan, remedies are primarily limited to injunction, annulment, and compensation for damage. Most biodiversity cases seek annulment of public expenditure decisions. So we have to wait once the damage happens. So we cannot stop. It's very difficult to stop before some harm occurs. So Ivan?
And as I said in previously, Australia under this national legislation has no merits review process, which essentially means courts are being asked, and this is the federal court in Australia, are being asked to look at the process of the decision in which the minister came to their view about approving a development which may impact biodiversity. The other thing which has crept in recent years, which is going down the line of climate litigation, less so than biodiversity litigation in Australia, is this notion that courts will not be entertaining these kind of high-level policy matters. And this is a really quite interesting development, which we saw, and some of you may have heard of the Sharma case, which we had in Australia, where a young girl challenged the decision of a coal mine on the basis that it would infringe the rights of future generations if the minister did not take into account climate change, which she didn't. At the first instance, the federal court said, you win, we agree with you. There is this kind of novel duty of care on the government to recognise that. But in the second instance on appeal in the full federal court, the judges at that level were almost kind of critical of the reasoning of the first instance and said, well, actually, it's not the only reason that it failed, but one of the major reasons was these decisions around climate change are high-level policy matters, and we as the courts actually don't want to have anything to do with them. That's for the Parliament to decide. So you see this happening in the climate change space. We haven't yet had a biodiversity case which has gone down the same lines, but I would not be surprised if someone brought the action on the basis that the government owed some type of duty of care that wasn't in legislation, that they would lose on a similar basis as a result of that reasoning in the climate change cases.
So the second point is court hesitancy to apply IVL. So we found this in commonality in this issue as well. So let me begin with the vagueness for IVL. In both in Japan and Australia, the language of the many IVTs is often IVT means international biodiversity treaties, and often not clear and precise. They reflect in international negotiation and compromises, so leading to vague and weakly normative content, so to obtain the minimum consensus, minimum agreement. So example, so obligation of the Ramsar Article 3.8.1 only seeks to promote conservation, and CBT Article 6 requires national strategy as far as possible, and in appropriate cases. And also narrow textual interpretation. When courts do examine treaty obligations, interpretations are often narrow and textual. So let me start with first in Japan. So Tokyo, Naha, and Sendai District Court confirms no specific obligation under WAC to protect specific sites. Fukuoka High Court in Kyushu area found CBT Article 1, 8, and 40 are abstract and requires measures as far as possible in appropriate cases. So Evan, you mentioned Australia.
Yeah, so the situation is very similar, which was interesting in an Australian context, at least for me to learn about in the Japanese context, that the court is saying the same thing. When they actually start to look into these treaties and they're being asked to make a judgment about whether a certain decision has met the standard in the legislation, which then takes I won't bore you with the complexity of it at the moment, but the legislation, whether that has been applied correctly, it then turns on whether the obligation in international law has been well considered. And the court says the same thing. When the court looks at these provisions, they take a very textual approach. And they end up, rather than a purposive application of the framework as a whole, in the cases I looked at in Australian context, I can't even see moving towards, well, let's look at the objectives of this treaty. Let's look outside at recent resolutions. Let's step back and look at it as a context. It's very much Article 4 is this obligation, and we've got the case here of the World Heritage Convention, and then when I read that down, it's essentially a very textual and narrow approach, and so a very similar result as what we had in Masako was saying.
Thank you, Van. And also, the non-binding resolution is also matters. So Japanese court refused to acknowledge IBL resolution and recommendation as having binding legal effect on the governments. And also Australia.
Yeah, so and the requirement is essentially that it's tied to this language of obligation, which, as many of you know, with international treaties, if you look into the treaty text, for starters, there's a challenge of actually how do we identify what an obligation is. Perhaps we would like it to be broader than what it is, but the general approach seems to be looking for words like shall and must and will and so forth in the language of the treaty in order to find that. The problem is that gets read even more narrowly when it gets to the domestic scale.
Yeah, thank you. So and also strict separation powers also matters. So both countries emphasize that separation powers. Regarding Japan, court avoid direct treaty application when relevant domestic laws exist, applying those instead. So we Japanese we formally as I mentioned introduced a monistic system, but we have some culture to supply the almost the same context in the legal system. We say in Japanese, kanzen tampo shugi. So this is should not infringe the legal domain of the political domain. So how and in Australia, you explain?
In Australia, we see, you say, kind of an absence of more activist courts. That's probably the wrong way to put it. It's more of a conservative view of coming back to what is the role of the judiciary in this separation of power system that Australia has. And the federal court continues to take this view, rightly or wrongly, that those matters about policy, high-level policy, whether it be about climate change or protection of biodiversity, irrespective of whether it sits in an international treaty or not, is the domain of the executive and not for the judiciary to kind of create or establish new norms that sit outside of that. Now, one of the last challenges I wanted to mention in an Australian context is this EPBC Act. The way in which it implements international treaties is interesting. It does what I would suggest is a kind of lazy approach or a very passive approach to implementation. So if you follow, this is a bit of a nightmare of a piece of legislation. I think several hundred provisions and all sorts of complicated mazes and so forth. But to distill it, there's a thread that goes through where ministerial decision-making about projects that impact upon the environment must not be inconsistent with obligations under international treaties. So this language of not inconsistent, or the minister must act not inconsistently, comes up again and again in the statute, and this has been litigated, right? And the courts are saying, well, that language of not inconsistent is very different from to act consistently with, right? And it might seem like splitting hairs, but what it is essentially doing, and it's quite deliberate in the national legislation, is to give the minister more discretion as to how they apply their decision making, so that what they're doing doesn't have to reach the bar of what they're talking about, but as long as whatever additional conditions they're putting on it are not inconsistent with the treaty, if that makes sense. So it's a far lesser standard than to act consistently with international law. Anyway, sorry, Masako, over to you.
Sorry, I don't. Sorry, I shared again. So this is a current concrete at this point, and we have some mention about future research. So key obstacle on the two countries will domestic legal and government and setting. Both Japan and Australia have legal and government setting that prevent comprehensive application of IBL by the judiciary. So and also courts in both countries generally adopt restrictive view of their role, preferring the interpreting existing domestic law rather than directly apply broad international treaty provisions. And also the non-specific and aspiratory language of many EPTs also contributes to judicial hesitancy. And a limited standing, lack of resources, and few remedial options for further restrict biodiversity litigation. So here, let me supply one thing in Japan. So in Japanese court system, judiciary can exercise their judicial power only when concrete case where the party can state their concrete legal damage or legal infringement. So many European countries can litigate the regulation itself. We say in climate litigation it's a framework litigation, but it is not possible in Japan. This also makes some big hurdle. So our future director might be further empirical and comparative analysis needed and better understand two factors, precluding more direct application by EBL in domestic law, and also propose possibility for overcoming their barriers. So this is all for our presentation. Thank you for your attention.
Thank you, Evan and Masako, for the overview of the biodiversity litigation using international treaty in Australia and Japan. So if I can summarize correctly, all of the cases that you've been observing are all judicial review. Is that correct? That request for the revocation or pending of a decision. So there is no like civil liability to address harm.
That's correct for the Australian situation.
Okay.
Same as Japan.
Okay. Is there any question from the audience? I can see that maybe the problem of having international law as a too abstract is common, and in many cases translation to national legislation might help the application in the court. Do you see this kind of policy direction happening so that you can have more cases in the court if the main hurdle is that treaty will be too vague, which is understandably because in international negotiation, usually country doesn't want a very binding obligation.
Can I add one thing, Rika-san? So far this is our conclusion at the time of the beginning of that July when we presented in IUCN. But after that, we have the ICJ's advisory opinion issued in 23rd of July. The advisory opinion mainly focused on the climate change, so state responsibility regarding to the climate change. But there, ICJ mentioned the CBD as a relevant treaties or regulations. So maybe we can I'm not sure, but there's a possibility that many domestic court in countries make some changes. We hope it will work.
Thank you. What about I'm quite surprised to know that at the national level there are fewer cases, Evan, in Australia, because in Indonesia Supreme Court, we work a lot with the New South Wales State Court because they have environmental court, and we get information of many environmental litigation from the New South Wales Land and Environmental Court.
Yeah, so that was kind of the federal distinction I was talking about before. So 22nd history. So before we had the Federation in 1900, everything was the colonies of England, right? Well, going back to 1788. So those states at the time have default powers over land use, including New South Wales, right? Then when they got to 1900 and decided to have a federation, they gave a certain amount of powers to the Australian government, But in 1901, there was nothing about the environment, right? Like the language didn't exist. So it's all telecommunications and lighthouses and all this sort of stuff, right? External affairs being one of them. So the separation between federal and state is fundamental to understanding Australian environmental law. So the court you're talking about is at the state level.
Yes.
And that you're right, there is a specialist environmental court called the Land Environment Court, which is very well known throughout the world, which hears cases, including criminal cases, including biodiversity, including climate change, at the New South Wales level. But the treaty system sits at the federal level. So if we're looking at the implementation of these international treaties, it's not 100% because there's nothing stopping the New South Wales government, for example, pulling principles out of the CBD or World Heritage Convention and so forth. But the more direct application is coming into the national level. And that's where I think litigants are finding a bit of pushback or inability there, right? If there was a specialist court, so to speak, at the federal level, fantastic, right? We'd have specialist judges. We wouldn't be going through the federal court, which also hears taxation and admiralty cases and bankruptcy and all sorts of other jurisdictions. But yeah, you're right. There is a specialist court at the New South Wales level, and they're very, very good. Justice Preston there is very good at pulling principles from international law, weaving them into judgments when needs be, and getting some very good decisions on behalf of the environment. But the nature of the claims are different too, right? As I was saying before, at the federal level, it's almost all judicial review and it goes to the federal court. So that's a very different action than the quasi and even merits review situations that exist in New South Wales.
Right.
And they may be winning on other things other than international environmental treaties.
Okay.
Yeah.
Is there any?
Very good. Very, very complicated state of affairs, unfortunately for us. Overly complicated, if you think about it. And unnecessarily so. But it is the historical thing that we live with.
Is there any?
Jakob?
Thanks. Thanks very much for the presentation. Really interesting and perhaps unsurprising. Lots of analogs to other countries in which we've worked, which I think is part of the reason that this kind of comparative empirical stuff is really useful. I'm curious, kind of back to that point that you were just making, Evan, though, kind of about your starting point, looking to international treaties as the hook on which we, the needle in which we thread. And I'm wondering, again, pursuant to Rika's comment about actually, it being different levels of courts, but I guess also, as you mentioned, Judge Preston also often relying on international conventions to inform some of his arguments, or some of his responses. But I'm just curious about that kind of top-down, referring to international legislation to build our argumentation versus kind of more bottom-up. And I realize that that's, very much contingent on what legislation already exists. One of the observations that we've made in our work is increasingly that we're really surprised by the incredible latitude that a lot of countries' legislation has relative to places like Australia or the UK and perhaps Japan, I don't know, but often isn't operationalized. I'm just curious about that kind of top-down versus bottom-up approach to thinking about biodiversity litigation. Which I realize is a cryptic question, but...
Well, it's not cryptic at all. And I also wondered about it when we were going through this research. And maybe this is the distinction. Like, I don't think Masako and I went into this going, this is the best way to do it. We were very much from an exploratory, what impact are these things having, at that domestic level? Are they getting traction? How are they being used? So it was kind of more exploratory as opposed to, is this an effective way of doing things? Because it turns out it's not particularly effective, at least for those decisions, right? That's not to say that there isn't this kind of wider impact that's also happening as a result of claimants bringing these things that are unsuccessful, right? Like policy impact and so forth, which we didn't look at. But yeah, I 100% agree with you. And when I was going through this, I was like, is this even the best way to get this level of traction, given the vagaries of these international agreements and so forth? So it was more of a, exploratory thing than anything else. But the barriers, once you start getting into the scale of it, the barriers exist at so many levels that it becomes very, very difficult to draw a direct line of, you should do this, why aren't you doing it, Masako, do you have any comments about the
Yeah, thank you. I totally agree with you, Ban. And also, when it comes to the biodiversity convention, conservation, maybe the most information is lies in the local level. So many citizens or people living there know everything. Not the top down, the government official. They have a very less limited in knowledge or information. So that interaction is indispensable. And we know we have the OFS convention, which protects the access to court or the access to information. So there, the citizen has a very a crucial role to make a bottom up to deliver their voice or their information. And I think it applies very critically in the field of biodiversity. How and also as I mentioned, the diversity conservation needs a multilateral agreement. So maybe, but however, the current system of the maybe a top-down lead, because there's a treaty made and it comes down from the top. But maybe, but the ideal way is maybe bottom up, and they to make together information what regulations needed. So maybe more about interaction will be very necessary, is my opinion. Yeah.
Oh, I would like to follow on that, Masako-san, because looking at how very conservative Japan is for legal standing, you require like a direct harm, and then everyone also said in Australia, you also like special interest doesn't just mean that I care about the environment. Does it mean that I just think then the local based harm will be more acceptable for the court, like rather than saying there is a breach of international law, then do you think it will be more acceptable for the court in the case where local people say our biodiversity is harmed, then we have standing, and then we want this thing to be fixed rather than they could draw from the international law, but then I think in the conservative court like that, they will be more open on the local harm-based agreement.
Okay, let me answer first. So I think yeah, you have I have a right point in some uncertain point, but when I think there hesitancy of the Japanese judiciary to apply international treaty is the same. Regardless, there are the issue focus more local or restricted damage. So Japan has some other in a local authority law, there's some system in which the local citizen can sue the local government for the expenditure or the public expenditure. There's no hurdle of the standings. Anyone the local audience can make the litigation, but the other issue is very difficult to prove the adequacy of the public expenditure. So maybe there's other problem because the expenditure is proceed some process and it once passed. So maybe even if we focus on the local harm, maybe other legal hurdle comes. Yeah. Evan, do you add something?
Not so much directly on that, but as you were talking, and maybe also back to Jacob's point, is that like a lot of there are other avenues for litigation to occur that bring in international treaties. So one of those potentially, right, for example, is through corporations and the claims that they make, the standards, the commitments, and so forth that they're making, because increasingly the bigger the corporation, it hangs its norms and its commitments and its ESG credentials on international standards, right? And so for human rights, it goes straight to the human rights treaties. And this is down another piece of work that I've been looking at for the banks and the financial sector. They hang things on the World Heritage Convention. We will not fund anything that happens in the World Heritage. It's like they're non-state actors, right? The bankers, they're proper non-state actors, right? They've got no status under international law or under those treaties. They've got no obligations. All those treaties are aimed at states. Yet they reach in and they pull some of these standards into their own commitments, right? Rightly or wrongly. But doing so enlivens them to a very interesting space of greenwashing and shareholder resolutions and all that stuff, right? Which is kind of happening. But the top down, bottom down, the scale thing is fascinating, right? Because I think it's so intertwined now that it can't be separated. It's like, so for example, in Australia, these notions of sustainable development, ecological sustainable, precautionary principle, all the big principles that come out of Rio and are found in the treaties, find their way into local level bylaws and so it's so intertwined now, even though the local council down the road doesn't realistically think it's got any obligations under the Convention on Biological Diversity. It has pulled concepts in there and it's using them as standards. So it's really kind of that messy with the scale question. But yeah, sorry, that was a bit of a diversionary comment.
Is there any more comment, Amanda or other participant?
Sorry. No, just Evan, I understand how complicated it is dealing with federal and state law, and my sympathies. This is why I don't work in that jurisdiction anymore.
Would you like to come back, Amanda?
God, no.
we're fighting. I say it's very topical at the moment, right? Because the government has just released its reform package for the EPBC Act that Laura was talking about before. I'm going to try to put in a comment for it and make submission and whatever. But it's just the same old, right? And it's a very lazy approach to implementation. It's risk averse, and it's okay. We want to give us, at the end of the day, we want to give ourselves discretion, which you can understand. But there's so much good stuff that sits in behind the frameworks, resolutions and so forth. If they wanted to, and if you're a bold government, if you actually recognize that natural capital has so much value for your society that you would do the right things by it, then there's an opportunity there to reach into it and use it. But they don't, because they're still so risk averse to it's an obligation on us, and we want to box ourselves.
But if it makes you feel any better, we've just finished, Hong Kong government's just finished their biodiversity strategy and action plan at the pushing of all the local NGOs and academics, and have decided, despite the fact that clearly we need to do things to comply with the convention, that there will be no legislative change at all. Nothing.
So how we will operationalize the...
So it's just going to sit in in other words, it's just a policy document sitting on the sidelines? Right.
Correct. Yeah.
And is that typical of the way the Hong Kong government has approached things in the last 2 decades, or is that?
Yes, definitely in the last 2 decades and before. I don't think you can blame the local government for this. The colonial government was just as bad.
Right. Well, yeah, that makes me feel a little bit better. I mean, but yeah. But these are urgent issues, right? And on the notion of urgency, so like desperate times call for desperate measures, so to speak, right? If you've got biodiversity declining at a rate like this, and you're tinkering around the edges with your legal framework, you're just going to be in the same position we
apparently we need a third runway, so that's more important than
You don't have any more land left, Amanda. You're going to have to.
We also don't have anyone coming to Hong Kong, but that's not going to stop the government.
Others like Francesca, Laina, Meow Meow, and Suhendan.
I see Jacob has a handing it.
Okay.
Yeah.
But no, over to the others. If anyone's got anything to add or any questions, please.
Yes. Usually Francesca is our most active members.
Meow Meow.
Hi, Masako and Ella. Thank you for your presentation. I have a question to Masako that I noticed you mentioned in Japan there are citizen participants in the litigation, and you also mentioned that it's really difficult to individuals to claim the harm. I wonder, does there is any other kind of plaintiffs in Japan, like the public authorities and, for example, prosecutors or administrative institutes like in China? And that will be easier for them to bring the case to the court than for individual citizens? Thank you.
Thank you so much, Meow, for the very, very important question. Yeah, if it's possible in Japan, it will be better. But as I mentioned, basically, litigation must be brought by the parties who can claim their individual harm or the individual concrete harm or damage. So it means that the mainly litigations expect some individual. So in Japan, it is very rare, including other fields of litigation like climate litigation, where the government becomes the litigant. So it's a very rare case. Maybe there's some exception, but at least in the field of biodiversity litigation, I cannot find any cases.
Okay, thank you.
Thank you. So, Hendan, our newest member, do you have any question, comment, or feedback?
Okay. Thank you for your presentation. It was so interesting. And I am wondering, in international biodiversity law, numerical targets such as 2030 goal are adopted through COP decisions. Yes, these targets are not binding, but could these numerical quantitative targets serve a basis for strategic biodiversity litigation in a way similar to how numerical climate targets have been used in climate litigation? Thank you so much.
Thank you. And then that's an interesting question because we've been talking about the barrier of having a concrete obligation. And as you mentioned, there are some numerical number target in the treaty.
Sorry, could you repeat? You mean you're asking?
Actually, in climate law, we have a numerical target,
Yeah.
1.5 degree, and these targets have been used in climate litigation. And now in biodiversity law, we have numerical quantitative targets also. So could these numerical targets lead strengthen climate biodiversity litigation? And yes, these are COP decisions and are not binding, but I'm wondering how can these targets play a role in biodiversity litigation?
Okay, now it's clear. Thank you for your question. Yeah, maybe in some countries like all European countries, or they maybe some NGO or some Spanish may use that kind of indicator to justify their argument. And but as far as Japanese practice of the judicial practice, as I observed so far, yeah, there may be a very limited expectation that court accepts that argument. But you are right. Some environmental NGO maybe can mobilize, and that I want to mention one more. The litigation, this kind of litigation, so-called strategic litigation, does not have objective only to win in the court, but make some impact to the society. So that is why they are called a strategic litigation. So maybe the mobilization of that kind of indicator has invoked some social argument. It's also one outcome of the litigation, I think. Evan, do you have something to add?
Yeah, this is a really interesting question because you're exactly right. Under the GBF, these targets have been agreed to, including by the Australian government. Legally, the answer for us would be no at the moment until they get legislated in such a way that it would enliven an action. So to give you an example, it took us 20 years to get climate change legislation in Australia. Longer, right? But finally, the government come up with some legislation 3 years ago. And everyone's like, fantastic, Climate Change Act, right, at the federal level. What's this going to do? And it enshrined Australia's target, which was consistent with the UNFCCC, right, as aspirational legislation. Says we're going to legislate our target, and then everyone's like, well, so what? What's the accountability mechanism there? The accountability mechanism is every year the minister has to table a document in Parliament saying whether or not they've, what actions they've taken to meet the target. So they keep it out of the realm quite deliberately of litigation, if that makes sense. So the only accountability mechanism happens in a debate in Parliament about whether they're actually meeting the target or not. So in an Australian context, yes, we've signed up to them. It would require a real forward, less risk-averse government to take them on, embed them in legislation, make them part of the decision-making process for when a minister declares a new protected area or doesn't, or proves a coal mine or so forth. And only then would it start to come in a real strict legal sense. But Masako, I could be wrong, but I think in Japan, your new Regional Biodiversity Act talks about the targets under the GBF, because it came in 2021, I think. I don't know if it makes them as a provision, as in a hard provision about what the government must do. But I could be wrong. It doesn't actually pull in the targets and say into domestic law, at least in the Regional Biodiversity Act.
Sorry, but I did not follow that the revision, but it is good to be, or other possibility will be not in the law itself, but some regulation under the law may adopt some indicator. Is that possible? And okay, I'll check soon and I'll share that.
Yeah. And then I think the other hook is, Suendan, if it says somewhere in the legislation, government must abide by its NBSAP, so that the plan, and then within the plan, it's got all the targets and all the actions and so on. So there are indirect ways to sort of bring it in.
Yeah.
But Australia is like, it was hard fought enough to try and get Australia to enshrine targets in national law.
Yeah.
We have Francesca have a problem with the mic, but she typed her question about the inclusion of biodiversity in spatial planning. To what extent international biodiversity law in both countries are influencing the consideration of biodiversity when conducting EIA?
So is the question, is biodiversity included in the EIA processes? Is that I can't see the chat. Maybe I'll go into the chat.
Yeah, and then yes, to what extent especially the international biodiversity law, does it affect your EIA system?
It does. So for example, in the national level, right, we have a interactive database which has all the listed species that are listed under CMS, the Migratory Species Convention, as well as the migratory bird treaties, right? So it maps the habitat. And then there's a requirement through the process that when the impact assessment is done, they need to look at this mapping and then therefore say whether there's going to be impacts on that habitat. So it does come in, right? But that's in the process of environmental impact assessment. When you get to the final ministerial decision about whether the project can go ahead, we fall back on this language of whether it's not inconsistent with the treaty. And they look at the treaty and go, well, let's have a look at the language of the treaty. Oh, the treaty says do your best efforts to protect the, so it gets through on the basis of the process. There are no red lines, so to speak. But yes, it is in the environment. We are very good impact assessment processes, and they're taken very seriously. Give or take a few things, but that red line does not exist. And NGOs and other people have been arguing for that red line in certain areas of habitat, which the government refuses. Right?
Yeah, thank you, Francisca. Thank you, Francisca, for the question, and I'm happy to see you here today. And also, Japan is almost the same. So, the overall consideration, there's the biodiversity is one factor. There's not only the not something which decides everything. So we are and also Japan does not introduce a strategic environmental assessment impact. So we start the process after one project was determined to conduct. So it makes very difficult to which place some project will be conducted, or so maybe very other decision consideration process is very late, as Evan mentioned the same thing. And currently, the new issues are becoming the conflict with wind solar generation and biodiversity with the migratory birds. So there are many conflict, and many local residents insist it makes bad impact on the birds. But many EIA process once consider that point, but in conclusion, it's considered very lightly.
Wait, so are you saying that the decision come first before the EIA started? You
So
already
yeah,
make your
almost.
mind that it will be winter solar in this area, then you have EIA?
Yeah. Some are very critical local residents say we have the very critical say assessment in Japanese we criticize our assessment. Our assessment in Japanese is just follow the style on the premise that the project will be done. So we formally follow the process, but there are some unhidden premise that this project will be done. So just follow the process.
Okay, that's difficult. If you already made up your decision even before the assessment is completed. Is there any one last question before we can conclude our 1 hour informal discussion? No? Jacob, previously you raised something. Okay. Thank you so much, Evan and Masako. Do you have any last conclusions or like way moving forward? Do you see how biodiversity litigation would be more fruitful? What is your forecast on the matter?
Okay, let me begin. Again, thank you, Rika-san, for giving us this opportunity. And this is my first time for make a presentation in BELS. And but I would like to I would like to be working with you colleagues so far. And also we want to I and Ivan will keep this this research as a continuing issues. And my regarding the utilizing the legal litigation as a strategy tool, as I mentioned, maybe the litigation is our final purpose is not win some concrete judgment, but make some impact to the government policy making process. So maybe we should observe not only the concrete outcome of the one legal case, but also we gather the information and how we make impact on the legal lawmaking process or policy making process. This is my final mention.
Thank you very much. Yeah, I also want to thank you for your invitation to talk to you today. I didn't know your group existed, and I actually love it. So, it's great to see like-minded people, and, hopefully I can get an invite to be part of these sessions in the future if you still have them. As for the future, look, I have a slightly controversial view, which is not agreed to by many people, other environmental lawyers in Australia, but I actually think the federal government should get out of the game of regulation and pull itself more towards, this is an Australian context, and this is a meta-level reform, right? More towards coordination and funding and resourcing and so forth in alignment with targets. So if they can show that states meeting, for example, the targets under the GBF by 2030, then they get the funding for that, and they have the kind of laggards and leaders and so forth, right? Because at the moment we have this duplicative regulatory system where both parties or both sides are passing the buck, so to speak, on the obligations to protect biodiversity, rather than this recognition that this is actually incredibly valuable resources, for want of a better word, to humanity. And so that's my view. I'm sort of more at that, what is the role of the federal government? What should it be? Because for the last 25 years, I can't see much. Out of how many thousands of projects, I think only 2 have ever been refused on the basis of this legislation, and the biodiversity continues to decline. So as I was saying before, I think it requires something more than just, I think it requires some sort of paradigm shift into how we think about the different roles of government and whether we want them to be a regulator. Because if we want them to be a regulator, then they better sure as hell be regulators. They better fund themselves. They better train everybody up. You don't have a kind of quasi-regulatory system, which is what they've got at the moment, and then not do it properly. So, yeah. I don't know if that's a prediction as much as it is a rant.
Thank you for your
Sorry.
case, Masako and Evan, for giving us a new lens through the international law, because we've been talking about national law during the previous discussion. And I'll see you in the next bi-monthly discussion in January. We have Suhendan, who have volunteered to present the French law on, what is it again? The ecological restoration in the French law. So
Ecological damage. Yeah.
yes, okay. So looking forward to see you all again in end of January. I'll fix the date with Suhendan after this.
Thank you so much.
Thanks for your presentations. Nice to see everyone. Nice to see new faces.
Thank
Thank you.
you.
Bye-bye.
Bye.
Thanks, Rika.